Okay, so we're just going to jump in and talk really high level right now about why special needs planning is different. So first and foremost, it is a lifelong plan, not a one-time event, right? Like I was mentioning before, my daughter was diagnosed when she was 4. What her life looks like now as a 9-year-old might change when she's 18, when she's 21, when she's 40, so it's something that is always ongoing, and it can't be something that you just plan for once and then set it and forget it, right? Your child's needs and abilities and everything, evolves from early childhood to school to adulthood to long-term care. So it is very unique, and I think a strong plan really has to grow with them and adapt as life changes. Many families don't realize how easy it is to accidentally jeopardize benefits. And we're going to talk a little bit more about benefits, but a gift from a grandparent, a savings account, an inheritance, even with good intentions, because let's face it, like people want to give to their children and they want to provide for them, can unfortunately cause loss of essential programs. So, the importance of planning and creating something that's going to protect access to services for your loved ones is really, really important. So, we're going to talk a little bit more about how we do that today. So, the rules, this goes back to like the last one, the benefits rules are very complex and interconnected, and there's a lot of hoops to jump through and a lot of red tape. So, eligibility for programs like SSI, like Medicaid, waiver services, they often overlap. And one change in income, assets, or living situation can really impact multiple benefits at once. So, families do need more guidance and support, especially navigating all these moving parts confidently, because a lot of the times you just don't know. Um, Traditional planning can really do more harm than good. So, Letty, can you just hit that button for me? Thank you. Standard wills and trusts, while they're great, and standard financial advice often doesn't account for benefit preservation. I was once in a scenario with a family that, worked with another advisor, and they never asked if they were caring for a loved one with special needs or a disability. And unfortunately, they put something in place where the child, who was an adult at this time, ended up losing benefits. So I think it's really important to work with people who understand and, account for benefit preservation. What works for a neurotypical child or a neurotypical adult may unintentionally disqualify them for, disqualify a child with disabilities, right? So you need to think about that. And then special needs planning really requires the specialized tool like, which we'll talk more about today, properly structured SNTs, which supplemental or special needs trusts. Um, Next, Letty.
Sorry, I'm not sure why. It just froze. There we go.
There we go. Every family situation is unique. No two individuals with disabilities have the same needs, goals, or support systems, right? I don't know what my daughter's future is going to look like. Letty doesn't know what her brother's future is going to look like. It's all different. So planning must reflect the person, their abilities, where they're going to be in the future, and the family's values. And it's really about, dignity, independence, long-term security tailored specifically to them. So that's kind of what we're gonna, talk a little bit more about today. Okay, so understanding government benefits. And Christina, if you want to jump in on these slides with me, go for it, but I'm going to cover the basics. Next slide, please. Okay, so first and foremost, SSI, Supplemental Security Income. SSI is really often the first major benefits that families encounter when a child turns 18. It provides modest monthly cash benefits to help with living expenses. Eligibility at 18 is based on the adult disability standard, and parental income no longer counts. Asset limits are strict, so planning ahead is essential to avoid disqualification. SSDI, which is Social Security Disability Insurance, it's different from SSI because it's tied to work history, either the individual's work history or a parent's. And many families don't realize that their child may qualify through a parent's record under the Adult Disabled Child DAC benefit. DAC eligibility can open the door to Medicare after a waiting period, and this becomes especially important for when a parent retires, becomes disabled, or passes away. Medicaid is often the backbone of care for individuals with disabilities. It covers medical care, therapies, long-term supports, and services private insurance rarely touches. Some children may qualify regardless of parental income through special pathways, which a lot of the times parents are never really told about. And Medicaid is also the gateway to many community-based supports. Medicaid waivers or HCBS waivers allow individuals to receive care at home or in the community instead of in institutions. They can fund respite, behavioral support, employment services, transportation, and more. Unfortunately, the wait list can be years long, which is why applying early is critical. And families shouldn't assume a school provider or care manager has already added them to the list. They really need to advocate for themselves.
Jillian, they provide self-direction services as well.
Yes, absolutely. Thank you, Melissa.
You're welcome.
And then in addition, beyond the federal programs or, state programs, there are additional programs like CHIP, which is Children's Health Insurance Program, family support grants. We mentioned respite programs, transportation assistance, housing support. So I would say first and foremost, really understanding government benefits and doing your own research if you haven't already on what is available to you and how you access those is very, very important, especially when it comes to your planning. Okay. So I don't know how many people have heard of the cliff effect, but basically, unlike typical, basically, even a small amount of excess in assets or income can cause your loved one to lose all of their government benefits if it's in their name, not just a portion. It isn't a gradual phase out, benefits just stop. So, unlike typical financial programs that phase out benefits, like that phase out benefits slowly, disability benefits often disappear all at once. So, even the smallest, minute, tiny increase in assets or income, literally a single dollar or a couple cents, can trigger a complete loss of support. The SSI resource limit is extremely low. So, the SSI's asset limit is $2,000 and it hasn't been updated in decades, which is horrible to think, but that is this very small number. The limit includes things family don't always think about. So you get those, checking accounts or savings accounts that were set up for your children. They receive gifts for their birthday with money in it. They have inheritance. There's insurance payouts, retirement accounts that families set up for their kids when they were younger, right? Things, all those things. You got to be aware of because it is very, very easy to cross that line without even realizing it. So well-meaning gifts can cause harm, and it's terrible because people again they want to give to their family, they want to give to their loved ones, and families often assume that giving money helps. But a birthday check, a savings bond, a small inheritance can unintentionally disqualify someone from all benefits. So that's why education is so important and everything needs to be structured the right way. If you do lose benefits once they stop, they don't restart automatically. Families may face months, sometimes longer, of reapplying, appealing, and waiting. And during that time, the individual may lose access to medical care, therapies, housing, so on and so forth. So structures matters more than amount. The issue isn't how much you leave, but necessarily how you leave it, right? And we're going to talk more about that today. So tools like S&Ts and ABLE accounts, they exist to really prevent this cliff and to make sure that the benefits are still, provided for the loved ones. The goal is not about restriction. I think a lot of people assume that, oh, if you put money into a trust or it's in a trust, then you're restricting that child or that loved one from accessing that money. It's not about restriction. It's about protection. It's not about limiting generosity. It's about safeguarding stability. So families can absolutely provide support, but it needs to be done in a way that preserves eligibility and long-term security.
And that is why it's so important that you have the core legal documents and that you do the proper planning so that when you want to leave assets to a loved one, it's structured in a way that they're not going to risk any benefits that they're receiving. So I'm going to start with the will. Most people know about having a last will and testament or just calling it a will. A will is a document that dictates how you want to leave your property when you're no longer here, who you want to inherit. The issue with a will is that it has to go through the probate process. So just because someone has a will doesn't mean that that's it. They still have to go through the court system. They have to ask a judge to have the executor who's nominated in the will actually appointed to carry out the provisions of the will. In your wills, if you leave everything to somebody who's receiving some benefits, the inheritance itself can stop them from receiving their services. So it's really important that you direct that an inheritance go into a special needs trust. And that can be done through a will. It could also be done through trust, which we'll talk about in a little bit. But when you have a will with somebody who's either special needs or has some disabilities, and we have to probate a will, they appoint a guardian ad litem for that person, and it could become very costly to your estate. It could wind up costing the estate $10,000 to $20,000 because of that. The solution is, instead of doing wills, we create special needs trust. It's a way to preserve and protect assets that you're leaving your loved one. There's different types of special needs trust. The first one is considered a third-party supplemental needs trust or special needs trust, which is when a loved one creates the trust for you. So I create a trust for the benefit of my loved one who maybe has some special needs or is already on governmental benefits, or maybe on governmental benefits one day. You can go to the next slide. So with a third-party supplemental needs trust, there's no payback provision to the government. So it allows you to protect the assets, continue for them to get their governmental benefits, and provide support. These types of trusts pay for things that the governmental benefits don't pay for, like vacations or cars, clothing, computers, cell phones, iPads, anything that the government does not pay for. Go ahead. So there's two types. As I said before, we have the third party, which is funded by somebody other than the beneficiary. Then we have first party supplemental needs trusts, that those assets are funded by the beneficiary's own assets. So for example, maybe somebody never had anything. They never had any assets. They were injured at a young age. They didn't have enough of work credits to go on Social Security disability. So they receive SSI benefits, but unfortunately were involved in a car accident. And now they're finally going to come into some money, whether it's $5,000, $10,000, $20,000. By receiving that from the personal injury award, they would lose their benefits. They would lose their SSI. And as Jillian said before, it could take months and even years to get back. So what we would do in that situation is we would create a first party special needs trust and take the proceeds from the personal injury award and fund that trust. And the downside to a first party supplemental needs trust is that whatever is left in that trust upon the person's passing goes back to the government. So they can't leave anything to beneficiaries until the government is first paid back. So with a third party supplemental needs trust, a loved one is the grantor and trustee. And the first party supplemental needs trust, the grantor is the person who's receiving the benefits, and the trustee has to be somebody else. Going into other types of trust besides special needs trust is revocable living trust. So a living trust is just used to describe a trust that you create during your lifetime. So there's different types of trust. Living trust is while you're alive, and testamentary trusts are trusts that are created after somebody's passed away. A revocable trust is a good tool to avoid probate. It's better than having a will. You're right, you could keep going. It helps the trust owner to create the trust plan that they need that could be tailored to their certain circumstances, whether they have a loved one who's on governmental benefits, whether they even just have a child who's maybe what we call the spendthrifter, who just likes to spend the money, and any little inheritance they'll get will be gone shortly thereafter. The grantor, the creator of the trust, can also be the trustee with a revocable trust. The downside to the revocable trust is that because the grantor still has control, there's no asset protection. So what is asset protection? You can
Oh.
Asset protection, no, you're good, keep going. Asset protection is used when we want to protect our assets so that we can eventually qualify for some governmental benefits later on in life. So Medicaid in general is both a federal and state program. So even though it's on the federal level, each state has their own rules and guidelines, and what assets you could keep in your name. So here in New York, in order to qualify for Medicaid, you can't have more than around $32,000 in assets. In other states, they're much lower. Some states are higher. So it's a means-based test that varies from state to state. Medicaid could pay for both long-term care, whether it's community in your home or nursing home in a facility, or even health insurance sometimes. So in order to help somebody qualify for Medicaid services who's maybe over the threshold or has too many assets, we create a Medicaid Asset Protection Trust, where the grantor is not the trustee. They just create the trust and somebody else has to be their trustee. However, even though we always hear that's an irrevocable trust, that doesn't mean that the grantor loses all control. So the grantor is always in charge of who the beneficiaries and trustees are. What makes it really irrevocable is that the assets that go into the trust can never go directly back to the grantor. The grantor is only entitled to income. Now I want to touch a little bit on like the lifetime documents that everybody needs once you turn 18 and over. So the first one is a power of attorney. What is it? A power of attorney is a document where you appoint an agent to take control over your finances should something happen to you. So you appoint an agent that can handle and conduct what I say is the business of you. Why is it essential? It's essential because without it, should something happen to you, get Alzheimer's, dementia, you become incapacitated, nobody can access your bank accounts, no one can sign your name, no one can do anything on your behalf. There's different types of power of attorney. However, here in New York, the basic power of attorney is the New York statutory power of attorney, which is a durable power of attorney. That means it becomes effective the day you sign it. There are other types of power of attorneys, but in New York, they're not widely used. When to set it up, as I said before, as soon as you turn 18, you should have it in place. We tell all of our families that have children going off to college, get it prepared and have them sign it on their 18th birthday. If you don't have a power of attorney in place and something should happen where you need to be able to sign their name or act on their behalf, you'd have to pursue what's called a guardianship action here in New York. Other states call it a conservatorship. This is where you go through the court and you ask a judge to declare your loved one incapacitated and to be appointed as their guardian. This process in New York can cost upwards of $40,000 and take over a year. The next document is a healthcare proxy. So this document is where you name an agent who can make medical decisions for you in the event you can't make them yourself. It's different from a power of attorney because it only relates to medical decisions. Again, your agent is able to make all medical decisions for you. When thinking of who your healthcare proxy agent should be, you want to pick somebody who's able to carry out your wishes. Oftentimes I hear, I'm going to make it my firstborn child, or I'll make it my daughter because I'm closer to her. It's really important that you can make it someone who, when faced with a difficult situation, is going to be able to carry out your wishes. A healthcare proxy takes effect as soon as a doctor says that you're not able to make your own medical decisions. And the next document that we talk about is HIPAA authorization. So HIPAA allows your healthcare agent to make informed decisions for you by having access to your medical records. So it has any medical records, test results, treatment plans, prescriptions. Again, you need this because the healthcare proxy, while it allows your agent to make your medical decision, it doesn't give him the authority to access those records. And then the next document that we like to always tell our clients that they should have, if they so choose it, is a living will. And again, this is different than a last will and testament. So a living will says whether or not you want to prolong your life. So if doctors have said that this is it, the end is near, do you want to be hooked up to machines, artificial hydration and nutrition, breathing tubes, or do you want to be able to go painlessly and freely as possible? So some people want this, some people don't. It could be tailored to the things that you do want versus the things that you don't want. It's more for your family members or your agents than it is for you, because you don't ever want them to feel like they made the decision. Did I make the right decision? What would mom or dad have wanted, or what would my wife have wanted? So it's always important that you think of your agents more than yourself. We also do something called a disposition of remains, and this takes care of end of life decisions. As it is, it's really hard to think about estate planning and talk to our loved ones. How many people actually talk about, do you want to be cremated or buried? Do you want specific services? What do you want? Do you want flowers, no flowers? So this helps your family know what your wishes are when it comes to your end of life care. Do you want to be an organ donor? Do you want to have, certain religious ceremonies? So all these documents are really important to do during your lifetime. Estate planning is important. Everybody should have it done. And going in, just to transition, going back to you, to Jillian and Letty, it's really important that you have a team of professionals to do this for you. Do you want me to keep going, Jillian, or you want to go back at it?
Joe.
Button. Letty, you go.
Okay. All right. So pretty much going back to everything, it's important to have your team, right? So we have a financial advisor who's gonna review all your saving strategies, trust funding, expertise, special needs attorney, to review all the documents as Christina just went over. And then we have trust and estate attorney. Then we also have a CPA tax professional as well to also review your trust able account and available deductions, benefits counselor, navigate SSI, Medicaid, and waiver applications and compliance. Care manager or social worker, coordinate services, therapies, day-to-day support system. Insurance specialist, life insurance, able account, and long-term care planning. That also goes in hand with financial advisors. And then we have making your team work together. So it's important for us to share the full picture, which is, it goes back to having that team. Each professional needs to understand the whole plan, not just their piece. Your attorney needs to know about your financial plan. Your financial advisor needs to know about your legal documents. Designate a quarterback. One person, often the financial advisor or care manager, should coordinate communication across all professionals to ensure nothing falls through the cracks. Schedule regular reviews. Your plans should be reviewed at least annually whenever there's a major life change, new diagnosis, change in benefits, or death of a caregiver. Also, keep a central file. Maintain one organized location with all legal documents, benefit letters, provider contacts, and plan details, so anyone stepping in can find what they need. And most importantly, to ask the right questions. Ask each professional, do you have experience with special needs planning? How do you coordinate with other professionals on the team? Now we jump into common red flags and mistakes, where Jill is going to review that with you.
Okay.
No, why does that? That's so weird.
Okay. So a few red flags that can really be costly to your family. Number one, leaving assets directly to your loved one. So Christina kind of mentioned this before. Even talking about the first party S&T, right? If someone passes away unexpectedly, a parent, a grandparent, whoever, and the beneficiary on a life insurance policy is in the name of the child or the grandchild or whatever, and they're inheriting that money, right? That can prevent them from access to their benefits because now they've received this lump sum of money. So we want to make sure that we're not leaving assets directly to your loved one. Leave the assets to the trust. Set up a trust for that.
I also think the biggest one, if I could just jump in for a second, is really retirement accounts.
Right. Yes.
Retirement
Who's the
accounts,
beneficiary on there?
right? They realize, okay, well, the only asset I have is my retirement, and people are so conditioned. Well, you have to be, what is it, 72 to make your RMDs, and you don't really take them till you're older in life, so they don't think that it's an issue for their children. But with the Secure Act and things changing, it might have to be taken out sooner than later. And even though it might be tied up in an IRA or a 401k for SSI purposes and Medicaid, that's an asset to the individual.
Yeah.
So, they'd either have to cash it out and then pay a lot of taxes on it, or lose their benefits.
Yep. Yeah, we come across that quite a bit. So, which goes to the next piece, right? Not updating beneficiary designation. So life insurance, retirement accounts, bank accounts, they may pass directly through your loved one outside of your will, bypassing the trust entirely, and that puts benefits at risk. So we just want to make sure that when someone is putting together a financial plan or an insurance policy in place, their retirement accounts, all the beneficiaries are updated to reflect the trust and not the individual necessarily. The other red flag is waiting until it's too late. So I think for me personally, my daughter was 4 when she was diagnosed, and now we're going through the OPWDD process, and we didn't realize like you should start young. You got to get these plans in place early on. So many families don't plan until it's a need or there's a crisis. Start early, get on wait list. Those can take 5 to 10 years in some places. So make sure you do that. Another red flag is really using a general attorney without special needs planning experience. So standard, we kind of went over this before, but standard estate planning documents may not protect benefits. So special needs planning requires knowledge of the field, and knowledge of benefit preservation rules. Another really big red flag is forgetting to tell family members the plan, right? You need to have a backup. You need someone to understand what you've put in place for your children. So grandparents, aunts, uncles, let them know and make sure that they understand that leaving gifts or inheritance directly to your loved one is, it could cause devastating harm to their benefits. I'm going to give you a personal example here. My grandfather passed away this past week, and my mom tells me today that Grandpa has all this money set aside and it's going to be passed down to you and your brother. And he also is leaving money to the great grandchildren. And I said, oh, including Avery, my daughter? And she's like, yes. And I'm like, okay, well, we need to talk about that because I wasn't aware, and I need to look at those documents to make sure that if anything is going to her, it's not in her name, and we need to figure this out. But it's important to really communicate that because you wouldn't think of it otherwise. You don't know what someone else's legal documents look like.
And I think that also ties into not using a general attorney who doesn't have special need planning or elder law planning. All of our trusts have certain what we call our just in case provisions, from having a special needs trust to having a bankruptcy clause in there to having a crisis provision in there. And, people always ask, but oh, nobody's on governmental benefits. My kids aren't. And my response is they aren't today. And hopefully they never are. But what happens if somebody falls on hard times, or the economy changes, or they get hurt at work, or they have a child that has special needs later on, and you're trying to do generational planning? It doesn't hurt to put it in there. It never hurts to have it in your planning. It hurts when you don't have it in your planning.
Mm-hmm. Yeah. All right. I don't know why it does that. More mistakes to avoid. Not planning for the caregiver's incapacity or death. So what happens to your loved ones if something happens to you? And this goes back to, just things like really, guardianship and power of attorneys and healthcare proxies and all these things that need to be put in place. Your plan has to include succession planning for caregivers, not just the financial side of things, because your child, maybe you have a child that's young now, but eventually that child's going to get older and you still may be supporting that child when they become an adult. And if something, God forbid, happens to you, there needs to be a backup plan for someone else who's going to step into that role. And it's really important to communicate who you want to step into that role and make sure that they understand what they're going to have to do, because some people might not want to step into that role. There might be godparents or aunts and uncles that say, hey, I can't handle that, you know? So it really is important to include that succession planning for caregivers. Another big mistake to avoid, and we're going to go more into ABLE accounts in our follow-up sessions. This was just really an overview, but ignoring the ABLE account, which we'll talk more about. Basically, ABLE accounts allow tax advantage savings up to $100,000 without affecting SSI. It was created under the ABLE Act of 2014, and most families don't know that they exist. So we're going to talk a little bit about ABLE accounts, how to create an ABLE account, how to fund an ABLE account, what you can use the ABLE account for, but ignoring that is a mistake to avoid. Number 8, assuming your other children will just handle it. So this goes back to what I said before. You know, most families, if they have, you know, multiple children, a lot of the times I see, and Letty's dealing with this personally herself right now, you see a lot of the times that the siblings take on a lot of responsibility, especially as the parents get older and as the parents, you know, need more support themselves. And you can't always assume that the other children are just going to handle it. You know, placing the burden on siblings without structure and funding and legal authority sets people up for stress and conflict. And they, you know, if they weren't raised this way or taught this way, that this is going to be their responsibility down the road, they most of the time won't know how to navigate it, and it'll just cause more problems in the end. So don't assume your other children will just handle it.
And if I could just add to that also, I get a lot of times, well, I'll just, you know, so-and-so is on governmental benefits, so I'll just leave everything to my other child and they'll make sure that they're provided for and taken care of. And I'm sure that they would, but what happens if that child passes away? Or what happens if that child gets divorced and accidentally commingles the funds? Or, you know, that child is applying for, you know, FAFSA for their other kid, the grandchildren to go to school. There's so many effects and ripple effects that can happen from doing something like that.
Absolutely. This kind of brings up the next one, right? Not reviewing the plan regularly. Laws change, benefits change, your family's needs, people change, situations change. A plan that worked 5 years ago may not work today. So you want to review it at least annually. It's interesting. There's someone we know who, you know, had a will, I think, or a trust set up for her children when she was young and she was married. And in the trust, it said something in there about her and her husband. And even though the father is still in the picture, she's no longer married to that person. So the language that says your husband, when now they're no longer husband and wife, that entire trust needs to be edited because the language is not the same anymore, right? Even though the father and the father's still alive, they're not married anymore. So now that document has to be changed. So review the plan regularly as life changes. The last thing is, you know, really thinking you could do it alone. This is tough. It is complex. It is emotional. That's why you need that team of professionals who really understand special needs planning. And asking for help is not a weakness. It is a strategy. All right, Christina, you want to take us home?
So just some important things to think about and remember from today's. I know we threw a lot at you in a very short period of time, but special needs planning is definitely different than regular planning. It's different than the traditional, just need a will or healthcare power of attorney planning to more intricate planning. And it's always important that you have the team behind you. The foundation of estate planning is having a will, power of attorney, healthcare proxy, HIPAA authorization, and the disposition of remains form. And if you have a will, you should make sure that it has all of those just in case provisions in there. You know, the dangerous mistakes are the ones that you don't know you're making. So always try to ask questions, follow up. You know, go into your attorney's office at least once a year just to review everything. Protecting eligibility all across programs is also essential. So somebody may be on regular Social Security disability, but getting Medicaid. So while their assets can be as high as they want because of the disability part, they're on regular disability. Because they have Medicaid, it can't be. So there's not just one standard across the whole board. I'm a big advocate, as I said before, you do need a team. Not one person can do it all. I can help you with the estate planning part and creating the trust and the documents, but we need the financial planner in to talk about, well, what do we have? What does it look like? And I always love to bring in the accountant also. What tax ramifications are this going to have? If we have a large retirement account, but somebody's on governmental benefits and we put it in the trust, is it going to be taxed at the trust rate or the individual rate? So having your team of professionals is super important. And you want to work with people who are willing to give the time and work with other professionals. Start now. It's never too early. It's only always too late. So for everyone attending today, we wanted to thank you so much for being here. 6 o'clock is a time right after work, getting things ready. Anybody who attended our meeting today, you could call us to schedule a consultation. We are offering $500 off our trust package, whether it's a revocable, irrevocable, special needs, any type of trust package. We have a few more seminars coming up. May 11th is our second session. We're going to talk about the ABLE accounts and protecting benefits for life. On May 27th, it's the IEP education planning and advocacy. And on June 11th, we'll end with some long-term funding after school age, building a sustainable adult life plan. Just make sure you guys register for each event. There'll be some emails coming out. And just to end it, I think we have all our contact information here, our phone number, our email. We do have several offices all over. We have one in Lindenhurst, Garden City, Wantagh. We also go to Brooklyn and Westchester. If you have a loved one who is at home and cannot leave the home, we do make house calls as well. We've gone to nursing homes, assisted living, hospital bedsides. Because like I said, it's only sometimes just too late and we're doing some crisis planning. If anybody has any questions and they want to ask, I could take questions for a short period of time. Otherwise, you could feel free to email us. So I'll open it up if anybody has any questions.
Hi, Christina. Good
Hey,
to see
Michelle, how are you?
Good. Where in Brooklyn are you? Where is your office located in Brooklyn?
That is
Brighton Beach.
Brighton Beach. That's a Leslie question. She goes to our Brooklyn office.
But we travel, so sometimes if, Brooklyn's pretty big. It takes me sometimes an hour and a half to get to different parts of Brooklyn.
East Flatbush, someone in East Flatbush.
Yeah, so we can always make accommodations if we needed to come like to a coffee shop or something like that if it's closer to you.
To the client. Okay, thank you.
Anyone else have any other questions?
Yeah, hi, ladies. Thank you so much. This was super informative. I feel overwhelmed now. Where do you start? Like, where do I start?
My
Just
honest
give a little
answer,
Yeah, where do I start?
my honest answer is call us for their free consultation. You give us a call. We have a few forms for you to fill out. We have something called an asset spreadsheet, so we can get kind of like a financial picture. We'll ask some basic questions. And then we have our consultation, I'll ask, what are the goals? You married, children, any special needs? What's your goals? What do you want? Are you looking to provide legacies? Are we looking to protect assets? Are we talking about minor children or older children? So it always starts with a consult, and I know it could be overwhelming. That's why we don't give like a whole package of documents. Some estate planning firms send you home with a whole questionnaire, 30 pages long, answer these all. We give you one little page, come in, have a conversation. Let's talk about what is it that you're looking for? What do you have financially? Who are your main family members and what are your goals?
And then Kim, also from a financial perspective, we do, similar, we'll have a free consultation with someone, go over all of your assets, everything that's on your balance sheet. We'll review beneficiaries, we'll look at retirement accounts, we'll, take a look at everything. And the good news about working with a team like that is if once we have all the information in place, it's easier for us to communicate with each other across the board if you were to move forward, and start working with both of us, just knowing, we kind of work together to go over that information.
Jillian, I just started following you on Instagram because I did have some questions about the
Okay.
Evil account. I
Yeah.
just feel like, yeah, I would contact you both and talk to you guys just because I feel like we're a unique kind of situation,
Yeah.
where our assets are not all in the US, like it's all over the place. So I'll just contact you both and then we'll go from there to see what is it that best fits for us.
And I think
Sure.
the best part of having that team is being able to say, I want to talk to both of you. I want you both on in the meeting, whether we're
Oh,
in Zoom, we
perfect.
come together, not hearing, well, you know what? Go talk to your financial advisor, let me know what they say, and then come back to me.
Hmm.
No, let's collaborate right here and right now.
Perfect. Thank you, ladies.
Anybody else have any other questions they want to ask?
I have
I have a
a
question. Oh,
go.
go ahead.
Okay. Brenda, go ahead. You go first.
Okay. My sister is 57 and cognitively and physically disabled. We have most everything going on, including a special needs trust. But what keeps coming up with her care manager through OPW, through her waiver services, her self-direction, is guardianship. And
Mm.
is there a reason later in life to want guardianship? Like, we've gotten her this far. She was declared 100% disabled at age 22, or in there, but she had IEP in school. But anyways, is there a reason that guardianship makes sense in an older person's life?
It,
Just
it
now that
makes
she's
sense
older.
at any point in your life because you're gonna hit, I'm surprised that you got this far without, encountering this. So there's different types of guardianships. When you have somebody who's disabled, as a minor, as soon as they hit 18, you should have guardianship over them. And then as they get older, people who become disabled and lose capacity at a later life, that's when they go for guardianship. So it might just be that you've been very lucky that people have always spoken to you all these years and maybe spoken to your mom. And because it was a parent, they felt like it wasn't necessary now that that parent is gone. Do you have multiple siblings? Like sometimes they don't want to deal with the legalese of, okay, if I talk to the one sister, not the other one, and this sister's making decisions and not this one, who do I listen to?
I'm the only one. We do have, I do have power of attorney. My parents and her parents are still alive. They're in their 80s, so I'm doing most of it now, which is why I'm trying to understand everything that's going on. But the care manager through that we have through the Medicaid self-direction is really pushing for guardianship, and I just want to understand why that would be so necessary, if at this age with if we have POA and healthcare proxy. I got to check on that with my mom. See if we have that in the
usually if you have
file.
a power of attorney and healthcare proxy, you don't need a guardianship. So, might just be getting an attorney involved quickly to just ask her. Sometimes, they don't realize that when you have those documents, unless they feel like they're defective in some way. But you usually only need guardianship when you don't have those documents in place.
Okay. All right. Thank you.
I have a question.
Mhm.
I already have an S&T for my, maybe it's less than a year old. Besides that, my daughter's just 13 and I want to say she has mild CP. So for me, I want to say that's what I was told that I should have for her to protect her benefits in the future, which we set that up. What else can I have? Or besides, I know that you are a law firm, so what other services can you offer besides the S&T? Do I need anything else?
Well, you should have power of attorney, healthcare proxy. You should have your own set of estate planning documents for yourself. And then for your daughter, no, the S&T is really the start, but the question is, what's funding the S&T and where is all of your assets going to go? Do you own your own home? When you pass away, where is that going? Do you have a will in place that says it's going to go to that S&T that you created for her? Or is it just going to pass, if you don't have a will, then it would just go outright to her. So it's making sure that all the assets that you have are directed to that S&T if something should happen to you.
All right. But I mean that I don't need to. I mean everything, all the assets to direct them to the S&T. But besides having the S&T, do I need anything else?
When she turns 18, she should have her own power of attorney and healthcare proxy, as long as she can fully understand what those documents are. And if it's, if it's mild, I'm sure at that point it'll be fine. But yes, as long as she has the capacity to understand what a power of attorney is and healthcare proxy, she should sign those, have them ready as soon as her 18th birthday.
Mhm.
All right. Thank you.
And then we can also, like I said, on our follow-up conversations, we're going to cover more on the ABLE accounts. So if that's not something that you've looked into, we're going to, provide more information on how to get that set up if you wanted to go that direction.
I'm sorry, could you repeat that?
Oh yeah, we on our next session, we're going to be talking about ABLE accounts more in depth. So if you haven't set that up, that's another way to just set aside money for your child down the road. So we can talk about that a little bit more in depth in our next session and how that process works and how to get those things set up.
All right, thank you.
Any last questions?
All right. Well, feel free to reach out if you have additional questions. Our information, Christina, was it in the slideshow?
I
No.
don't think so. Want to
Okay.
put it in the chat?
Yeah, I'll put my email, my information. Letty will put hers in there. That way you guys could take that down. If you do have any further questions on the financial side, we're happy to connect.
Yeah, we can also even send an email with our information as well, with if everyone is comfortable with that, we can do that.
I just searched you guys and found you.
Mhm.
All right.
Well, hopefully we'll see everybody back here for part 2. So it's Jillian put her contact information in the chat. If you guys want to take it down, I'll leave it open for a little while longer.
All right. Thank you all for attending.